Good morning, or good afternoon, or good evening, or whenever you're listening to us. My name is Leonardo Lampret, and welcome back to 15 episodes of Scale and Tales. Today we're going to talk about should a claimant automatically receive schedule loss of use when the record contains no opposing medical evidence. And to make a long story short, absolutely not. A claimant does not automatically receive a schedule loss of use award just because there is no opposing medical evidence in the record. The burden is still on the claimant to produce a credible, sufficient medical evidence establishing there is a permanent impairment. Even in the absence of rebuttal evidence, such as, for example, carrier producing their own IME, the board is not required to accept a medical opinion at face value, especially where the report is internally inconsistent, lacks objective support, or fails to comply with the impairment guidelines. The board cannot simply default to awarding a schedule loss of use because one report went unrebutted. Something similar actually happened in employer Cinelli carding CO INC with a WCB number G275 5818 from March 2nd, 2026. Alright, so here's what's going on in this case. The claim itself is established for injuries to the left ankle and back from a work accident on March 6, 2020. Now, on August 2, 2022, the claimant is evaluated by her doctor who submits a permanency report. In that report, he lists the claimant's range of motions for the left ankle, and notably, every single measurement he gives is essentially normal. Full dorsiflexion, even greater than normal plantar flexion, normal inversion, and eversion. Despite that, for some reason or another, her doctor assigns a 30% schedule loss of use of the left ankle. Now, the case comes back in April for the hearing. The judge ends up precluding the carrier's medical consultant because the doctor didn't show up for a deposition. So with no opposing medical evidence in the record, the judge adopted claimant's provider's opinion, basically saying, and I quote, "This is all I have," unquote, and awarded the 30% SLU. But here's the problem. Even if there is no opposing medical opinion, the claimant still has the burden of proof presenting credible medical evidence to support a schedule loss of use award, and that's where his report fails. The board panel reviewed the medical report and took a position that on its face, the report doesn't support a finding of permanency. The ranges of motion he reports are normal across the board. He doesn't explain what impairment justifies a 30% schedule loss of use. He doesn't mention any special consideration, and importantly, he doesn't even indicate that he took the required 3 measurements for each movement under the guidelines. So you're left with a report that says full function, but somehow, for one reason, concludes a 30% schedule loss of use, without any explanation tying those two together. And under the 2018 impairment guidelines, that's just simply not enough. Well, the board panel actually did not buy the BS either, and ultimately found that there is no credible evidence of permanency in the record, rescinded the schedule loss of use award, and allowed the claimant to reopen the case if a new medical evidence of permanency is produced. And since there is no award, there is also no attorney fees at this time. Now, in other words, the claimant bears the burden of producing credible medical evidence to support a finding of permanency. The mere absence of the contrary medical evidence does not relieve the claimant of that burden, nor does it require the board to adopt the claimant's medical opinion wholesale. Whereas here, the medical report fails to comply with basic rules of the applicable impairment guidelines, it cannot serve as a basis for a schedule loss of use award, regardless of whether or not it stands unopposed. Thank you, and see you next month.